Welcome back to Good Law, Bad Law. My guest on this episode is Marci Hamilton. Marci is one of the country's leading experts on child abuse, child sex abuse, and neglect. She's a lawyer, a professor, a writer, an author, and she has worked very, very closely on the issue of Catholic Church sex abuse of children. And we're talking about this incredible, historic grand jury report that has come out of the Pennsylvania Attorney General's office this week that details hundreds and hundreds of victims and hundreds of perpetrators inside the Catholic Church over 10, 20, 40, 50 years of time. We're going to talk about the report, what its findings are, and what can be done, and why the law needs to be reformed to allow victims of these horrendous crimes to be able to bring their claims in court. A fascinating, important episode about law and also about justice. Stay tuned. Welcome back to Good Law, Bad Law. On this episode of the program, we are talking about the Catholic Church and the most extensive, most comprehensive, and most horrifying report by a grand jury looking at decades of sexual assault and abuse of children in Pennsylvania. My guest today on the program to discuss this, what it is and what its significance is one of the country's leading experts on this issue, and it's a pleasure to have you here, Marci Hamilton.
Thanks for having me.
Marci, you have written a book about this topic. You have a nonprofit organization that you have started to deal with this and other issues relating to abuse and neglect of children. And you are a professor at my alma mater, the University of Pennsylvania Law School. So tell us a little bit about yourself, and then let's get right into the subject of this incredible grand jury report that came out this week.
Sure. So I was a law student here at the University of Pennsylvania and ended up clerking for Justice Sandra Day O'Connor and became a law professor. So for 26 years, I worked on issues involving religious groups that break the law. I was the only law professor doing it. Largely, I was doing it because I had a case at the United States Supreme Court, Bernie v. Flores, and defeated the Religious Freedom Restoration Act. So,
and just remind us what that was, because that's not a small achievement.
So Bernie v. Flores was the case in 1997 that addressed whether or not the federal government could pass a law, the Religious Freedom Restoration Act, RFRA, that could set a standard for religious liberty that had never been seen in the United States before. We persuaded in telling the Supreme Court it was unconstitutional. It was an unexpected victory. There were many that thought the court would say, hands down, RFRA is a fine law. And the result was all the groups that lobby against religious groups started contacting me. There were no law professors in the United States in religious liberty issues that were on the other side of religion. And as a Presbyterian married to a Catholic, I never thought I would be. But the more I was approached, the more I learned about child abuse, child neglect, breaking laws in religious groups. So when the clergy sex abuse crisis hit, it literally landed in my lap, and I've been working on it ever since.
Well, let's get a little of the background on this, and that will help us understand in context why this new report by a grand jury in Pennsylvania that revealed hundreds and hundreds of perpetrators in dioceses all over Pennsylvania and hundreds of victims, and really documents their story in incredible detail. Let's go back to the beginning, as you say, of this crisis. And does that go back to the Boston expose on the Catholic Church's practices there?
It does. So in 2002, when the Spotlight story came out, which of course became a major motion picture movie of the year, we learned for the first time, not about child sex abuse. We knew that was in existence, but we did not know that there were very powerful men in power who were actually covering up for pedophiles. And so that story hit very hard. But the initial response to the Boston story was that, oh, it just must be Boston. I remember Rick Santorum, the senator, saying that, well, this doesn't happen in Philadelphia because Philadelphia is not as liberal. It was because Boston was some kind of liberal stronghold.
Right, he's a former Republican senator from Pennsylvania.
Yeah. All true.
Wow.
So, but there was a tremendous amount of pushback by Catholics and everyone, everywhere. Nobody wanted to believe that the institution that you always wanted to have their clergy on your jury now was the institution that was actually imperiling children in large numbers. So when the story started to come out about Gagin, who was in his 80s, and Shanley, who was actually a member of NAMBLA, the North American Man-Boy Love Association, the details started to sink in. Now we started to hear from survivors in other parts of the country. We saw SNAP, the Survivors Network of Those Abused by Priests, become very public. This all kind of snowballed into a moment when, long before the Me Too movement, we had the clergy sex abuse survivors walking into the public square and saying, Me Too.
But some important parallels to the Me Too movement.
I would say that this movement, the clergy sex abuse movement, is the historical precedent for the Me Too movement. Right. This whole concept of telling the public and trying to help everybody else who's had the same problem, that really was rooted in the way in which the Catholic victims first started to come forward. But it wasn't very long until it wasn't just Catholic victims. It was Jehovah's Witness victims, and then it was Jewish victims, and then it was Penn State, and then it was all of the private boarding schools, including in Pennsylvania here, the Solberry School. This all added up to the point that we now had a certifiable epidemic of child sex abuse in the United States. And as that became more well understood, that it also became a global issue.
And an epidemic of victims whose victimization goes back 10, 20, 30 years or even more.
Right.
And lots of special problems in the law that present because of that.
Right.
Which we need to talk about.
Right. So, I was drawn into these cases early on as a First Amendment expert. So I was brought in to help craft the arguments against the church's arguments that they had a First Amendment right not to do discovery. They said they had a right not to be sued. And there are states to this day that actually have cases like Missouri, the Brewer case, which holds that you cannot sue the Catholic Church for sexual abuse.
Because of the First Amendment.
Because of the First Amendment.
Okay, that's a new one. I've never heard of that.
3 states, Utah, Wisconsin, and Missouri, have cases which say you can't sue the Catholic Church for sex abuse. So I became the person who was crafting the legal arguments and assisting the clergy sex abuse attorneys on those First Amendment arguments. But very quickly, I learned that we would have a case and there would be one victim. And I'd be reading about the case, and then there would be 20 other victims mentioned, or there would be siblings. But none of those people would be involved in the case. And I would say to the lawyers, what's going on here? Why aren't you representing everybody? And it was the same answer again and again and again. It was the statute of limitations. And I frankly could not believe a deadline, a very arbitrary procedural mechanism. This technicality was the only reason that one person out of 50 was able to bring a lawsuit or to be able to prosecute. So I had this great idea that I would just write a book about it. And I had already written a very academic book about religious liberty, and I would have a column for years and years. I thought, no, I'm going to write a book for legislators, and it's going to be very short, very readable. It's called Justice Denied, What America Must Do to Protect Its Children, and it lays out very quickly, here's why child sex abuse victims need time to come forward. Here is this terrible state of our law on sexual abuse statutes of limitations, and let's get rid of them.
Well, and just before we dig deeper into that, and just so people listening understand, the statute of limitations is a case killer. But there's a reason, generally speaking, for it in the law, and that is, right, so a statute of limitation is a period of time within which you may bring a claim, and after which you may not.
Right.
So for a lot of tort-type claims, injury kinds of claims, the statute of limitations would be, generally speaking, 2 years,
right,
although it varies a lot from state to state.
Right.
And often for children, the statute of limitations is longer in many states, but not long enough for these kinds of cases where someone might have been 8, 9, 10, 12, 14 years old at the time that they were abused, and they're coming forward many years later.
Right. So, we have statutes of limitations for contract claims and property, and they tend to be short. You want to get these things settled and determined. You want everybody to know who owns what, who has obligations. Murder has no statute of limitations. So the question that falls in between is, well, what about child sex abuse statutes of limitations? Does it belong on the murder end of the spectrum, or does it belong on the contract end? And the more I studied it, the clearer it became to me that it clearly belongs with the murder end of the spectrum. These victims are disabled. They don't understand what's happening to them, and the trauma keeps them from coming forward. So on average, a victim needs until age 52 to come forward. So when we have short statutes of limitations, even when they're in their 20s or 30s, we're still shutting out most victims. But the real irony is there was a time when we thought of child sex abuse as like a broken leg. So you just assumed the kid understood they'd been hurt, they go tell their mom, and it'll get taken care of. Yeah. Instead, it doesn't work like that. So at one point in our history in the United States, the statute of limitations for child sex abuse would be 2 years from the date of the act. So if you were a 6-year-old who was assaulted by your uncle, if you didn't come forward by age 8, it was over. Yeah. So we then extended them generally to age 18. You got to age of majority plus 2 years. Well, then that wasn't long enough. Right. And so now we're in a full-fledged movement.
Okay, and we're going to talk a lot more about the statute of limitations. That is the key.
Yes.
That is the key to something more than what is already happening. So, okay, so we go from Boston, where this, where this really the lid comes off the issue, but it's localized. It's still possible to localize that and say, well, that's Boston. But Pennsylvania then gets drawn in pretty heavily. And give us that background, too.
So what happens is that Lynn Abraham is the district attorney of Philadelphia. And unlike any other prosecutor in the United States at the time, in 2003, she says to her staff, we're going to figure out just how bad of a problem this is in Philadelphia. She instituted a grand jury in 2003. She then reinstituted another grand jury and brought me in as an outside consultant. I was the expert who helped with the crafting of the legal remedies and what to do next. So in 2005, we published a grand jury report on sexual abuse in the Philadelphia Archdiocese, over 400 pages, the first of its kind. And it laid out the sexual abuse by dozens of priests, hundreds of victims, and it was shocking. Now, it was an era when the bishop still had the capacity to do a lot of name calling. And so she was immediately accused of being anti-Catholic, which was ridiculous because the detectives that were on this case were Catholic and devout Catholics. And so the 2005 grand jury report was a groundbreaker. What it said was, we have all of this crime. We now know it's been a terrible problem in the city of Philadelphia. But because of the statute of limitations, we can't bring one prosecution.
And that's makes this so exceptional, right? Because grand juries are used all the time.
Right.
They hear evidence by the prosecutor. They hear testimony of witnesses, and then they will recommend, if they think the evidence supports it, criminal charges to be brought. And that's how we know grand juries are used all the time in cities and communities all across the country. But here you have this 400-page report documenting all these crimes, and the grand jury can do nothing. Right. Well, I wouldn't say nothing. I mean, they do create this incredible report.
Well, and we recommended the elimination of the criminal statute of limitations, and we recommended the revival of expired civil statutes of limitations, and fixing the child endangerment law, mandatory reporting. So what came out of it was this felt sense of injustice, that all of these victims had been left behind, but that there could be something that could be done. Mm-hmm. So that was, that really set the standard. And it's because of that report that Pennsylvania now is the leader in the United States on child sex abuse grand juror reports involving institutions, not just the church, but institutions generally. Well,
okay. So how does the grand jury report that was just issued. It was just we're recording this on Thursday. Our episode will be posted on Friday. This grand jury report comes out just 2 days ago. So what is different or unusual about this grand jury report?
So what's historic about this grand jury report is it now fills in the gaps for every diocese in the state of Pennsylvania. After the Philadelphia grand jury reports, of which there were 3, there was one that was done on the Johnstown Altoona diocese, which was
is in Western Pennsylvania.
Western Pennsylvania, also devastating. In fact, it actually had a payoff chart where it showed you the type of sexual abuse and the amount of money they were paying off on it in a very neat and tidy chart.
Paying off victims?
Paying off victims,
wow.
$100,000 for rape and et cetera. Wow. So those 2 grand jury reports were in place. Penn State, the Solberry School in the Bucks County, and this report comes out. What this report does is it means that we now know about sex abuse in every diocese in this entire state of Pennsylvania. No other state comes close to this. No other state has done what Lynn Abraham did in 2005. But what we do have now is this extremely valuable historical document telling us the scope of the abuse, the number of victims at a minimum, and the number of perpetrators at a minimum. It's eye-opening, but it's just so important for understanding the scope of this problem.
Well, this is the first paragraph of the report, which I think is so powerful, and people should know that it says this. And we'll post a link to the report too. And if you don't read the whole thing, read the introduction and read some of the stories that are documented here. But this is how the grand jury report itself starts. We, the members of this grand jury, need you to hear this. We know some of you have heard some of it before. There have been other reports about child sex abuse within the Catholic Church, but never on this scale. For many of us, those earlier stories happened someplace else, someplace away. Now we know the truth. It happened everywhere. I mean, when you say filling in the blanks, there is no running, there is no hiding from this, right? This is on a scale that is pretty hard to imagine, and yet this report gives you the evidence that's unavoidable.
Well, and it gives it to you in detail. So it's an 886-page report. It has 450 pages at the end, which are appended by responses, with responses by bishops and priests. So it's by far the longest report. It's the only report that has responses that are built into it. Even though by law, someone who is mentioned in a report can add a response, this is the first time it's actually been done. So it is gigantic. 1,000 victims, over 300 priests named. And I can tell you that it's not all of them. I've heard from survivors in the last several days, all of whom have said to me, "Where's my perpetrator?" And so this is a beginning. It's still not completely comprehensive.
Now, you say there were 1,000 victims identified in this report, or who are covered by the details in this report. Of the 1,000 victims, how many of those could actually still bring some kind of claim, or could still have the crimes that they are victims of prosecuted?
Well, sadly, only 2 priests were capable of being prosecuted for child sex abuse as a result of this report. So 2 victims brought claims against each of their priests. That happened before the report was issued. So they issued those indictments early. The report itself was not accompanied by any new indictments.
Could that have happened? Could there be new indictments along with the findings of this report?
It's my view that the hierarchy should have been subjected to indictments for child endangerment.
So, right, let's understand that, because that is an extraordinary view to take. And this is a report the Attorney General of Pennsylvania, who sort of is the sponsor of this report, Josh Shapiro, is very proud of. And what it does in scope and in the historic nature of it is quite an achievement. Now, what I hear you saying, though, is that this doesn't go far enough. And so spell that out. When you say that the leadership or the hierarchy should be charged, tell us exactly what you mean by that.
Well, if you read enough of the report, you will see the callous disregard that the hierarchy had for children again and again, whether it was the vicar of clergy or it was the bishop in that particular diocese. It is pretty ugly. And, there was a moment in Pennsylvania history where the hierarchy would not have been guilty of child endangerment. But when Monsignor Lynn was prosecuted, he's the first ever prosecution in the United States of a Catholic member of the hierarchy for endangerment of children. He was convicted. The Superior Court reversed that conviction, saying, well, he wasn't really responsible for particular children, therefore that's not child endangerment.
And he was never accused himself of having assaulted or abused a child. He was convicted in his role as, in effect, a supervisor.
In his role as a supervisor and administrator of essentially the list of known abusers. So after he won at the Superior Court, it was appealed by the prosecutors back up to the Pennsylvania Supreme Court. The Pennsylvania Supreme Court said, wait a minute, he surely could be capable of endangering children, even if he's not responsible for particular children. If he creates danger for the children in his organization, that's endangerment. And so they threw out the reversal of the conviction. He is now awaiting retrial here in Philadelphia on child endangerment.
But what I hear you saying is that, and this is often the way the law evolves. In this, the Supreme Court has declared that there is a claim. They've essentially set the law in Pennsylvania that someone may be charged for this, and now they're going to have to retry him and see if he will be convicted of that charge.
Right.
And so you're saying, now that the Supreme Court is declared that this is the law and one could be charged, you're saying they should apply that law and bring charges.
So from the beginning of this report, I assumed that the payoff would be the indictment of the hierarchy. We have been dealing with the injustice to the victims for a very long time. There's a very specific solution. We know what we need to do. So do the members of the state legislature. But what we haven't been able to do is hold the institution to account. And the only way to do that is by holding its leadership to account. So if you noticed, Graham Spanier, the president of Penn State, is in jail. Right? Why? Because of endangering children.
And that's the Sandusky case you're referring to.
That's the Jerry Sandusky case. Yeah. That's Penn State. The same is true here. We have one higher-up after another who callously disregarded the suffering of children, who let pedophiles closer to them, who knew exactly what the result would be.
And this report details that pretty compellingly, right? This isn't just about a whole bunch of pedophile priests. I mean, they were known to the hierarchy. They were shipped around from location to location. They were sent to rehab, at certain designated rehab places where that's where you sent the priest to for this. So, I mean, those are the kinds of facts.
Right. They didn't just know that they had abusing priests. They knew the MO for each priest. They knew whether this priest was going to go after a 12-year-old boy or if this priest was a danger to 6-year-old girls. They knew that. In fact, I've often said that the experts in the world on child sex abuse are the secret archives of the Catholic Church. That's where the facts lie. That's where the expertise lies. These bishops knew exactly what they were doing. And if they didn't, it's because they didn't want to know. It was criminal recklessness. And so my view was that there should have been charges that were filed against each and every one of them. And let the chips fall where they may. They may not have succeeded in with all of them, but they certainly would have succeeded with some of them. The country of Chile recently, the Pope visited. He said some things dismissive of the victims. He was then forced to admit that the bishops of Chile had both covered up abuse and some of them were abusers. He went into that country and removed every single bishop. Why? Because they covered up abuse. Why is that not happening in the United States? Well, probably because of the power of the United States, probably because of the size. We need prosecutors to do that. And until someone takes these bishops seriously as criminals, we really are not going to see change. This will not make any change in this church. 2 indictments of priests will not make any change in this church unless we see actual criminal charges that make a difference to the people who matter in the church.
Now, is there still time to do that? Because we started
There
talking
is.
about the statute of limitations earlier, and we have to separate now the criminal charges that could be brought, this child endangerment charge, and civil claims that could be brought by the victim. So let's discuss each. On the criminal side, what is the statute of limitations for the criminal endangerment charge that we're talking about?
So the endangerment charge has a relatively short 2-year statute of limitations, but that's not a problem because for all of these dioceses, the public was unaware of the facts in their secret archives until Tuesday. So if you think about Pittsburgh has been one of the most frustrating dioceses in the United States in trying to get information about sex abuse in that particular diocese. The press in that city has not been terribly responsible in delving into the issues. The bishops have not been forthcoming. We are told by Cardinal Wuerl, who's now running Washington, D.C., that he was doing everything he possibly could. That is simply not true. The secrets about child sex abuse in Pittsburgh were literally under lock and key until Tuesday when the report came out. My view is that child endangerment clock did not start ticking until the report appeared for every single one of these 6 dioceses.
Right. It sounds like a fantastical story, but the report documents that there were lists of priests.
Always.
They were kept in a safe, and the bishop was the only one who had the key.
That's a policy in the entire church.
Right. I mean,
that's just the way they do it.
Yeah.
So in some ways, I really would just wish that Congress would hold hearings and say, okay, bishops in the United States, just bring your secret archives. Until they let loose with what's in their secret archives, they're sitting on poison, and they're going to continue to be poisoned by those archives. In the state of Pennsylvania, this grand jury report details lots of what is in those secret archives, but none of us knew of the full scope of the cover-up for real until Tuesday.
Okay, so we're talking now about what can be done. I mean, this report and the Philadelphia report and the Johnstown, PA report that came before, these have laid out the facts in a way that cannot be denied. So now we're really talking about, okay, what can be done? One thing that you're saying could be done if the Attorney General had the will and the courage to do it would be to bring some prosecutions of bishops and the other leadership of the church in Pennsylvania, and conceivably beyond Pennsylvania. Right. It was felt that there was knowledge beyond Pennsylvania, and do that and bring criminal charges.
Absolutely.
Based on the evidence in this report, which is 2 days old. What about civil claims? Now, that's a much tougher row to hoe because of the statute of limitations, isn't it?
So it is increasingly clear that the only way to level the playing field for the victims is to create a statute of limitations regime for child sex abuse that says you come forward when you're ready. In other words, we need to eliminate this criminal and the civil SOLs, and then we will help the future. But for those victims in this report, for every single one of them, they don't have a civil claim. We have to revive their expired civil statutes of limitations. We have to create what is called now at this point a window. And what a window is it's a time period, a year, 2 years, 3 years, during which the statute of limitations just doesn't stop you. Mm-hmm. You still have to prove your case. You still have to have a case. Yeah. You still have to do all the depositions and all the rest of it. But there isn't this arbitrary time frame. And so right now in Harrisburg, there is a bill that's been pending. Mark Rossi has had a bill. Tom Mert has had a bill. So this idea of reviving the expired civil SOLs has been around. We proposed it as long ago as the 2005 grand jury report.
It's been around for more than 10 years.
More than 10 years.
Yeah.
So we've been working on this every single year, and we get closer and closer and closer. The only answer for the victims from the past is to revive their claims. The problem is that the bishops continue to get the ear of lawmakers on what to do about clergy sex abuse. In some ways, if that doesn't turn your head around, I don't know what will. We have lawmakers that defer to the bishops on justice for victims of child sex abuse. when the bishops are the reason
Yeah.
that so many of these victims are in trouble. So it's the answer is easy. We've done it. We've seen it. We know that we did it in Delaware. We've done it in Minnesota, Hawaii. We've seen how it has operated in Connecticut, in Massachusetts.
And what? These are states that have relaxed the statute of limitations in the ways you're talking about?
That's right. So these are all states that have let people whose claims have already expired still go to court.
Okay.
And we have two bottom lines, and I've been studying this for years. ChildUSA.org on its website has a chart which explains it, the relative success of these kinds of approaches. We end up having a modest number of claims, but we have a significant number of claims that come forward, and they tell the public things that nobody knew. The only way for the victim to get the truth about their abuse is through the courts.
Well, now, I've always understood the statute of limitations as representing a balance. On the one hand, you have a victim of some wrong who has a right to bring a claim in court, and you want to allow enough time for that person to do that, to bring their claim in court. On the other hand, we think of the wrongdoer, the one who would be held accountable if the claim was brought in time. We think of that wrongdoer having the right to not look over their shoulder at a certain point, whether if it's a contract or if it's a car accident or something like that. After a certain point, we say that person has the right to repose, to rest, and not worry. Why do you think that the perpetrators of these types of wrongs should never have the comfort of relaxing? In other words, why does that balancing of interest not work here in these types of crimes?
Well, there's a fact answer and a legal answer. The fact answer is that perpetrators abuse well into their elderly years. So if you say that a victim can't come forward after a certain age, it's very likely that their perpetrator is just moving on to other victims and doing it scot-free. So that's one aspect of it. The other factual aspect of it is that the trauma is very real that blocks the victim from the capacity to come forward. It's very unfair to put a victim in the position where they have to come forward before they physically and emotionally can. But the legal answer is actually really interesting, and that is that statutes of repose are on the downswing. Statutes of repose increasingly are simply not a part of the law. A defendant does not have a right to be able to sleep at night if they've committed a crime. 100 years ago, statutes of repose were quite strong. It has increasingly been the position of the courts, and particularly the United States Supreme Court, that they are supposed to defer to the state legislatures and the federal legislature on these kinds of practical questions, procedural questions. So there really is no right, and certainly not in the state of Pennsylvania, for a perpetrator of child sex abuse to say, oh, from now on I get to sleep tight at night because I know that nobody can come get me. So that's not an argument against the elimination. The argument against the elimination that the bishops have made, and they're the only ones who publicly oppose, the insurance companies are in the background opposing.
I was going to ask you about, because insurance companies I could see have a big interest in this too.
They do. They are definitely in the shadows. It is in their interest not to pay on claims they've already covered.
Right.
But the bishops argue that it's going to bankrupt them. And this is sophistry at its best. Because what they really mean is that if they get into enough hot water, what they'll do is they'll file for voluntary Chapter 11 bankruptcy, they'll reorganize their wealth, and they'll reduce the payment per victim. They've done it again and again. So
I didn't know the Catholic Church had a money problem, actually.
It does not have a money problem. Not only that, it's the largest landowner in the United States.
Yeah.
Try to, just for fun some afternoon, try to figure out how much the Philadelphia Archdiocese owns in property. It's virtually impossible because much of it is not in the name of the Archdiocese. Most of it isn't. Much of it is in the name of a particular priest, or it's in the name of a small group. So only they know how much they're worth, and because of the tax laws, they don't have to tell us how much they're worth.
Now, I know you told us that one of the objections that came out when this first started coming to light in Boston, when that happened, and I'm sure the same was true when DA Lynn Abraham was working on this and you were working on it with her. One of the objections is this is anti-church, this is anti-Catholic. And I know a lot of your work has been around issues relating to religion and the law. Why? What's wrong with that argument? Why isn't this? Why is this an issue that's got nothing to do with the fact that actually this is a church, as it has everything to do with it that it's the church?
So the first time I wrote a column on these issues, I immediately received an email from Bill Donahue. And Bill Donahue is the head of the Catholic League. And he's kind of the attack dog for the bishops. And he wrote to me and he accused me of being anti-Catholic. And I responded by saying, actually, I'm really anti-child sex abuse in every context. And by the way, my husband's a devout Catholic. My husband is a devout Catholic, but he's a militant on these issues. And so the notion that you're being anti-Catholic because you're trying to root out child sex abuse is the flip side of the truth. The truth is this poison is destroying the church. If they don't figure out a way to solve the fact that they're poisoning themselves, they're going to be the ones who are the losers. I'm not opposed to the Catholic Church or any other church. In fact, I'm a believer. But I am deeply opposed to orchestrated systemic child sex abuse that is put together by men in power who have no moral compass when it comes to children.
Well, we're now kind of getting into the philosophical part of this discussion, and I'm glad we are because it's really, I think, so powerful and gets at a lot of what the motivations are on all sides here. So obviously for the victims, you hope that they have some opportunity to have their day in court. Otherwise, they're left with telling their story, and there may be value in that. There certainly is value in that. The grand jury report is a historical record of what's happened in the past, has value just for that purpose it serves. But to have your day in court, and I say this too as a trial lawyer, I say this as a former journalist and a historian. I mean, having a day in court has meaning, or may have meaning, even beyond what it means to that person. And so I wonder if you could talk about that a little bit, because it seems to apply so clearly here.
Right. So these cases are really important. First, because they shift the cost of the abuse from the victim over to the ones who caused it. That's critically important for fairness. That's important for the public to understand, that we have not only ignored these victims, but we have saddled them with all the costs of the abuse, while we know full well who caused the abuse. So that's part of it. But the other part of these lawsuits is that you learn about perpetrators and mechanisms and the ways in which institutions fail to respond to children's needs through the lawsuits. You won't learn this in any other way. And so while this report is lengthy, it is, after all, about 1,000 victims and over 300 priests. You have a snippet of each of those individuals' actual stories. We won't know the full story unless these victims are permitted to leave that cave of darkness and to be able to come forward, file a lawsuit, do discovery, and get the facts in the public record that everybody deserves.
Yeah. You know, I mentioned this to you when we were chatting before we started, that the last project I worked on as a journalist before I went to law school was a book about the Holocaust and the war crimes trials in Germany after World War II. And I think a lot of people probably know that the major Nazi figures, like Goering and others, that there was a Nuremberg trial. But I think a lot of people don't realize that those trials continued for many years in Germany as the lesser figures were rooted out and brought to justice. And I was reminded of some of the things that I was thinking about when I wrote that book, when I was thinking about this topic, because the subject of the book I wrote about was an 80-year-old man when he was brought to trial in 1990, having committed crimes during the Holocaust and during World War II, 40, 45, 50 years earlier. But there was a point to his standing trial, sure, for the crimes he committed and for the victims who were still alive to see that happen. But as a country, Germany wanted this trial, actually wanted this to happen. And there were those in the country who said, why do we have to go through this again? Why do we have to be accountable. This was in the past. We don't have anything to do with that. But there was something important about the exercise of going through being accountable for what you've done. And, I wonder what you think about that here. We probably are hearing a lot of statements of goodwill and intention from leaders in the Catholic Church. You told us about the example in Chile. But can those intentions really be carried out, with credibility if you haven't come to terms with the past?
The one of the great aspects of a report like this is that it really isn't just about the Catholic Church. It's about child sex abuse in every context. So every victim is listening and reading about this report, not just because they might be Catholic or not, but because they are part of this universe of having been a child sex abuse victim. Our legal system has set up unintentionally, in my view, but quite clearly, a message for these victims. And that message is, you can't move fast enough to get to court, so your claims really don't matter. So by the way, the abuse was your fault, and so was the lack of justice. And by the way, you've got survivor's guilt because others were abused after you. That's your problem. So
good luck dealing with all of this on your own.
You're all on your own.
Yeah.
So what happens when you can have these public proceedings, whether or not it's before a jury or it is all papers and there's a settlement at the end, which is what happens for most of these victims, is that it is a way of saying to every victim out there, it's not your fault. The law has now ruled it's not your fault. You are a victim. What was done to you was wrong. And as a system, we are going to do something about it. So long as we keep the statutes of limitations as a fence around justice these victims can't get into, the message is you don't count and we don't care. And for me, that's the reason that I dedicate so much effort to this issue. That is just cruel and unfair.
Marci, just before we finish today, just tell us a little bit about Child USA, because I know that you write, you teach, but this is also something very important to you. And what we've been talking about so far is one of the issues that Child USA deals with. So just give us a bit about that, please.
So I operated as a sole law professor with 6 research assistants, running essentially a nonprofit for a number of years, and finally realized I needed an organization to be able to house all the data that we were generating, but also to help victims everywhere. And so 2 years ago, we started Child USA for the purpose of creating a think tank to prevent child abuse and neglect. We don't do any direct service. We study these issues, and then we put together the laws and the policies that will actually protect millions of children at once. So it's an enormous task, but it is an honor to be able to do it. And we are looking at the incidence of abuse and neglect of athletes. We're looking at what are the impacts of gay conversion therapy on young people. We have formed an independent commission to study what really happened with the Nassar scandal in all of these institutions. Nobody is studying the Nassar scandal that hasn't been hired and has a client. We are an independent group of 16 experts from around the country, and we're going to address that and issue a report.
And we will put a link to, in our description for the episode, we'll put a link there so people can get to the website. It's a great website with a lot of information. Just finally, it is fascinating to me. We're here in Philadelphia. You're at Penn. My office is here in Philadelphia, and it is fascinating that Philadelphia and Pennsylvania really are leading the way on this issue. What impact do you think this will have in other parts of the country? I mean, do you hear already that other states are undertaking these types of grand jury investigations so they can document what has happened in their communities? Is this reverberating, do you think? Or not enough, and it should?
What's frustrating is that prosecutors are not picking this up. So that Lynn Abraham started something, set up a paradigm, which has now been copied and replicated in the state to the point that Attorney General Josh Shapiro has put together this amazing report. But other states are not stepping up. Prosecutors are not stepping up. They're elected officials. I think that they falsely fear that will affect re-election if it looks like they are so-called going after the church. Josh Shapiro gets it, fundamentally gets it. The side of the angels is on the side of the victims. And so we're not seeing a proliferation of studies like this. What we are seeing is increasing interest and activity for statute of limitations reform. We just finished a study from 2002 to the present on what are all of the changes that have happened. It has been very, very busy, but it's getting busier. And so what these studies do is they help inform the whole world on why you need SOL reform. So far, I don't see a lot of prosecutors stepping up and putting in the resources that are needed.
But if you do get statute of limitations reform, that opens the door for victims to come forward and press their claims, and that becomes another avenue for bringing all of this to light.
So we filed an amicus brief with Bishop Accountability in the proceedings involving the grand jury, and our argument was there's only two ways for the public to get full information about clergy sex abuse or child sex abuse. One is through a grand jury report. The other one is through statute of limitations reform. Either will take us down the path of getting the information we need, but we need them.
Marci Hamilton, thank you so much for being on Good Law, Bad Laws. Great to meet you too.
Thank you.